Yes, Mr. Allen.
Good afternoon, my ladies, my lord. My lord, can I deal first of all with the question of jurisdiction? And in relation to jurisdiction, my submission is that the question of law is adequately identified in the Tughans claim form, which is at core bundle tab 11, page 158, when read in context, and it is certainly within the permission granted by Mr. Justice Henshaw. The substance of the question of law has remained the same, and applying the guidance in the cases of Popplewell and Kossinex, which were referred to by Mr. Justice Foxton at paragraph 129.5 of his judgment, the issue in substance has been identified in the claim form. If alternatively that was not the court's view, then I would invite this court, as a matter of its discretion, to grant permission to amend the issue of law as identified in the claim form by the addition of the words in substance. My lord, I have copies of Popplewell and Kossinex that they would be helpful for the court. I hope I fairly summarised them.
I also have them.
I'm very grateful.
It's quite familiar territory.
Can I just develop that submission briefly?
Yes.
The court is now familiar with the background, but it is a slightly unusual one in terms of how the point of law now finds itself before this court. The origin of the never entitled formulation, if I can put it that, is in fact the concession that was made by Fenchurch Law on behalf of Tughans by their letter dated the 30th of July 2020, which is referred to in the judgment of Mr. Justice Foxton at tab 7, paragraph 31, page 77. Paragraphs had been extracted from Fenchurch Law's letter of the 30th of July 2020. The original basis on which the, subject to the qualified claim, but the original basis on which the arbitration took place for the arbitrator was on the basis that the position of the partners was that if the court was to conclude that it received a payment of the fee because of a misrepresentation, it could not seek an indemnity to cover a loss of a fee to which Tughans was never entitled. And a similar point was made in paragraph 54. So at the time of the first partial final award dated the 5th of July 2021, the Tughans partners had in fact made no unqualified claim in respect of the Tughans success fee. And that claim was only first made after the partial final award, and that was addressed by the arbitrator's final award at paragraphs 7 and 8, which the court had seen, core bundle tab 14, page 191, and his declaration at paragraph 17.2 at page 194. Insurers then sought permission to appeal against the arbitrator's declaration by its claim form, and one can pick up the story again from Mr. Justice Foxton's judgment at page 110 of the core bundle. And identify in paragraph 126 that Tughans' skeleton argument for resisting permission to appeal took the point that even if the letter of engagement had been induced by fraudulent misrepresentation, that did not mean it was void. And so that contention was before Mr. Justice Henshaw when he granted permission to appeal on the 2nd of January 2022. And if I can remind the court, which is the supplemental bundle at tab 18.
Well, we've got it at 127, haven't we? We've got the relevant bit of paragraph 14 set out.
It's summarised there.
Well, it's quoted, actually.
Yes.
That's the bit of paragraph 14 that's quoted, I think.
The proposition that a professional indemnity insurance covers a claim for a payment of a professional fee on the ground that the firm received a fee as a result of fraudulent or negligent misrepresentation or otherwise improperly.
Yeah.
And so there, the question of law was identified, and as Mr. Justice Foxton himself found, given that formulation, Mr. Justice Henshaw had no cause to consider the issue whether the Tughans success fee fell due as a matter of contract. And in our submission, the question of law is there squarely identified. It was before Mr. Justice Foxton, and it is essentially that same question of law that is raised in this appeal. And it is apparent from exchange from the court, my learned friend, this morning, that's so from paragraph 5 of my learned friend's skeleton argument for the hearing before Mr. Justice Foxton, which we looked at this morning at tab 20 of the supplemental bundle at page 263. So I say, in substance, the point has been identified in the claim form. Even if for some reason I'm wrong about that, the point has been argued. There is no prejudice to either party, nor has there been any suggestion of any prejudice. And therefore, I'd like the court to proceed on the basis the question of law has in substance been identified in the claim form, alternatively as necessary to manipulate the question of law by addition of the words in substance into the claim form. Well, that's what I wish to say in relation to the question of jurisdiction. Can I turn to my own friend's submissions? And of course, I had the benefit of the opportunity of dealing with a number of questions in the course of my submissions, and I don't propose to repeat that which I have given already by way of answer to those questions. But if I may come back briefly on various of the points raised by my learned friend, the court will know that I submit that this court must consider as a matter of substance, applying the guidance laid down in Castellane, must consider whether the insured, as between the insured and the insurer, has suffered an insured loss such as to attract an indemnity. And our submission is that a fee which would never have been paid but for the fraudulent or negligent misrepresentation that does not fall into the category of an insured actual loss. Now, my own friend took you to the decision of Sir John Weinroth in the Mortgage Corporation at tab 15 of the authorities bundle, and my Lord has, I hope, my submission that the judge essentially ruled there as an ancillary benefit was not to be taken into account, and I submit our position is quite different, because the Brown-Rudnick claim is by reference to the very thing which procured the fraudulent, or was procured by the fraudulent or negligent misstatement. My learned friend also submitted that one had to look at the question of the transactions, and his submission was that you can take account of the representation and the action wrong, which gives rise to the liability and damages, but you should leave out of account the fee that was paid pursuant to that contract. And we say that approach runs contrary to the indemnity principle because it makes no logical sense to take account of the claim damages for misrepresentation which one must proceed on the basis should not have been made, but to ignore what that misrepresentation procured, which was the success fee. And my answer is similar in relation to the second point he made, which was that the amount of liability should be the basic measure of loss. And of course that may be right as a general proposition, but applying the principles identified in Castellane and applied thereafter, the question of what loss has been suffered by the insured is one, I say, to be considered as between, for this purpose, between the insured and the insurer. And we come back to my central point, that this is a fee that would not have been received at all but for the fraudulent or negligent misrepresentation. And so accordingly, it can be described as a gain, or it can be simply described as a sum of money that falls to be taken into account. And so when one is identifying whether there is an insurable loss or whether a loss has been suffered, one takes into account the receipt of the fee. And I say that that approach is also the answer to my learned friend's suggestion that I was seeking to align negligence claims, or what I would say in relation to misrepresentation claims that applies equally to negligence claims. As I hope I made clear in the course of my submissions, it is not my submission. I'm not submitting that there can never be a claim in respect of a liability for damages by reference to fees. I gave the example of a solicitor who acts on a piece of litigation, renders invoices, the invoices are paid, and there is then a missed limitation date, or unless order isn't complied with, something along those lines, and the client makes a claim in respect of the fees paid. But that's fundamentally different in my submission to the present situation, which is where the fee has only been received consequent upon the fraudulent or negligent misrepresentation. And although there is a legal and beneficial entitlement at the moment of receipt, it is the solicitor is receiving that inevitably on the basis either the contract might be rescinded and a claim may be made for the return of the fee, or a claim for damages. Fourth, my learned friend pointed to clause 9D of the PII policy, which makes certain provisions in respect of claims for dishonesty, or where the underlying claim involves dishonesty. And my submission is that the court has to have in mind the principle of indemnity when construing the policy as a whole. It is a professional indemnity policy intended to afford cover to insurers in respect of claims arising from the conduct of practice as a solicitor. But as I have already submitted, its purpose in my submission is not to afford cover in respect of losses arising or said to arise in respect of a fee which would never have been received but for the fraudulent or negligent misrepresentation. Fifth, my learned friend made the point that the question of liability should not depend on the size of the fee, and the court is not in a position to make such an assessment. And whilst I would submit the nature and size of the fee in this case was certainly very striking, I agree that for the purposes of the question of law, that is not a relevant factor to be taken into account. But the court does not need to make that assessment. We're back to my central proposition in respect of the indemnity principle. My learned friend then made two further points, or responded to two further points that have been identified by insurers. First, the question of the interrelationship with claims in restitution. And secondly, the question in respect of unpaid fees. And as Lady Justice Andrews identified this morning, I think this is what one might describe as a subplot or a sub-issue in the sense that I am not submitting that the Brown-Rudnick claim as a whole should be regarded as, in truth, a restitutionary one. That's not the burden of my submission. Indeed, it's not something for which I would have permission to advance. The submission I make is whether the claim in respect of the Tughans success fee was brought as a compensatory one for damages for misrepresentation, or a restitutionary one for a return of the fee following rescission. The insured does not suffer an insured loss to which the policy responds. And my overarching submission is that by application of the indemnity principle, it's a sum of money which falls to be taken into account. Now, for my part, perhaps ironically, in this respect, have no issue with the analysis of Mr. Justice Foxton and what he says, which were considered this morning at paragraphs 112 and 113 of the judgment, saying that the policy does not respond, or, well, I should say, first of all, my reading of that, I take the point about the heading, and the heading is a reference to fees not being due, but when one looks at the analysis undertaken by the judge, the finding at paragraph 113 in my submission would appear to be of general application, and I submit is right for the reasons he has identified. My learned friend took you to 4 cases. He says in support of the what we're seeking to respond to the proposition that professional indemnity policies do not generally respond to restitutionary claims. I think I can deal with those relatively briefly rather than taking you back to them. It was the run of 4 cases starting with Stone and Rolls. My central submission is this. The terms of the professional indemnity policy can certainly narrow the scope of cover. And for instance, they're not relevant to this appeal, but there are material differences between the minimum terms and conditions in England and the terms of the policy which the court is considering as agreed with the Law Society of Northern Ireland. But that does not mean that if the express limitation is not present, that there is no cover, that there is cover for a restitutionary claim, particularly in respect of a fee. And as the court knows, I submit that that's something to which the professional indemnity policy does not respond and is accurately described as being in the nature of the reversal of a gain. Finally, on this topic, my learned friend addressed the question of unpaid fees.
Sorry, just before you leave restitutionary claims, it's your submission, therefore, that irrespective of the language identifying the scope of cover, if there is client money held by a solicitor, which is then stolen by an employee or diverted, let's say it's the proceeds of purchase of a house or it's money on account of fees, is it your case that because of the application of the indemnity principle, PII policies simply don't provide cover to partners for that situation if the claim is brought in restitution?
Lord, I would not go that far, no.
Don't you have to?
Well, then you have to say, well, it all turns on the terms of the policy. It doesn't have anything to do with the indemnity principle.
Well, it's perhaps I can express it another way then. That there is a material difference between, in terms of the application of the professional indemnity, or of the indemnity principle, between the position in respect of client money and the position in respect of fees. Now, in the minimum terms and conditions, it's actually addressed by a particular carve-out in relation to the definition of claim. But that isn't present in this policy. But
Sorry, when you say it, where is it expressly addressed in the England and Wales version? Or?
Well, we don't have that. We don't have that before the court.
Yes, but I would just wanted to understand what you were referring to.
The definition of claim is extended so as to include a breach of the client account rules.
In this policy?
No.
Oh, I see.
No. I was making the point that that is a position that might be covered by the specific terms of the policy. I'm not submitting that it's expressly covered by this policy. But
I mean, it is. Obviously, it's not surprising to accept that there ought to be cover in the circumstances that I've identified, because that's perhaps a paradigm example, both for the purposes of protection of the public and the sort of cover solicitors would want and expect to have, and is very common. So if we are looking at whether that would be covered under the wording of this policy, if there's nothing in the indemnity principle that prevents it, it would be surprising, wouldn't it, if on the wording of this policy it wasn't covered.
Well, my lord, sorry, it depends what, forgive me, it depends what my lord means by it. There's a material distinction between client money and fees, particularly fees that have been, I say, procured by misrepresentation. In the example which my lord is identifying, client money has been stolen by
an employee.
Partner or an employee.
It's, let's say money on account of fees. So the distinction between the money and fees may not be a sound one. It may be the distinction you're wanting to draw is between earned and unearned fees.
Well, my lord, yes. We come back to my submission as to that the principle of indemnity should mean that if the firm of solicitors it ends up with a sum of money that in substance it is not entitled to, either because it's pursuant to a contract that could be voided, or the client may take a different route and bring a claim in damages, that firm has received a sum of money which it should not have. The client money situation is different. It's received the client money for a particular purpose, buying a house, whatever it may be.
In this case, it's got its fees in return for services, so yeah, that's not a distinction.
But leave aside the buying a house. Let's take money on account of fees, and there's an element of them that's not yet been earned, and they ought to be in the client account. And as we know, sadly, it's not uncommon for solicitors to mix them with their own money and remove them from the client account. Take that situation. Now, the money is probably within the category of fees, but there's a difference, you say, between earned and unearned fees. There we're talking about unearned fees, and it's the client money. But why on earth, both from the point of view of public protection and solicitors' indemnity, should they be worse off if they've earned the fees than they are if they haven't earned the fees?
Well, I think, my lord, we're back to my central proposition, which is when one's considering the application of the indemnity principle, if the fee has only been received as a result of a negligent or fraudulent misuse.
No, we're not on the facts of this case. We're on your submission that restitution, a claim for restitution, is, as a matter of generality, not covered by PII insurance, which you were putting
Well, my lord, yes.
initially on the footing that that's because of the indemnity principle.
I would.
And I think you were then having to row back from that a little and say, well, it all depends on the terms of the policy. Or is that unfair?
I'm not sure that is entirely unfair. It may depend on the terms of the policy. But also, there's a restitutionary claim which is for the reversal of a gain is one thing. And my submission, that wouldn't be typically covered.
All restitution that's based on unjust enrichment is for the reversal of a gain. At least according to the authors of Goff and Jones.
But we're...
That's the problem. You see, I can see the point, the general point, the bigger picture point you make about, well, they're never entitled to the money in substance, which is the point you keep coming back to. Understandably, it's the heart of the case. But if we're just looking at a question of claims in restitution, I can't see at the moment how you can draw a distinction between one claim in restitution and another claim in restitution, because the essence of the claim is, by the claimant, you, the defendant, have got money to which you're not entitled to keep. And you've got to give it back to me. Or you have made off with my money, which ex hypothesi you weren't entitled to use, and therefore you've got to make restitution to me. In my Lord's example.
My lady, yes, but in this case, and it may be this is the indemnity principle as quantification, if I can put it that way. In this case, there has been no making off with the money. In the example of the stolen client account monies, the stolen client monies, they've gone. Here, the fee is procured, received, and retained. So
why does that make a difference?
Because then it falls to be taken into account as between
so if the recalcitrant employee parked it in a bank account to which there was access, then you wouldn't get cover either.
Well, my lady, there'd be no loss in those circumstances. Here, we have a particular combination of factors which involve the procuring of a fee by the misrepresentation that wouldn't otherwise be received, and in addition, the retention of it.
So is the distinction between money that the solicitor has access to or has in physical possession and money which is gone and vanished?
Well, certainly, if we think about the reliance on the Castellane Authority, the point there is that they've been paid the value of the house and they've been paid the consequences of the fire. And in this case, it's rather the equal and opposite. The liability which the solicitor's firm has is in respect of a fee received and retained, which otherwise wouldn't have been.
So if they'd spent it, they'd be okay?
Well, I'm not sure that's right, my lady. If they had, in those circumstances...
Well, they paid some of it to the Inland Revenue.
Well, lady, I'm made submissions in relation to that in the context of the respondent's notice. The decision that was taken in that respect seems to have been was to treat it as partnership income and distribute it to both equity and salaried partners. As it happens, not notwithstanding what was known about the circumstances in late 2014 and early 2015.
Which might or might not prove to be an impediment.
Well, my lord, I must accept that we haven't yet had the trial of the Crown Arbitration. My lords, can I turn to the respondent's notice, which I addressed in part, and I think for similar reasons to the exchange I've just had, it's not. I'm not inviting the court, in the context of the respondent's notice, to determine the position in respect of HMRC or the position in respect of the National Crime Agency. That's plainly not. It's been canvassed in the skeleton arguments, the arguments for or against, but that's not something which this court is in a position to deal with. You have my headline proposition that the partners have chosen to distribute the money and when they could have returned the fee. But can I just deal with one point that has emerged, if only to invite the court to be very wary about how it approaches it, or that it should be loath to deal with it. And that's the proposition that one must look at the individual position of each partner and the illustrative figures that my learned friend has identified. Because what seems to emerge from that is the proposition that, as I now understand it, is the proposition that because there were 10 equity partners and 10 salaried partners, actually, as I understand it, what seems to be being said is that whilst there is 4 million that is still retained, it might only be 2 million that should ever be taken into account, because half of that money has been distributed to salaried partners who haven't been sued as defendants. That's as I understood the submission that was made, including in terms of what the open offer meant.
I'd understood it differently. I'd understood it to be the composite insurance point, which is, although we've been referring to throughout the Tughans, actually the Ashords in this case are a series of individuals, and you have to look at their cover, and their cover is in respect of liability, and their liability is in respect of the whole of the success fee, but the benefit they receive may be rather less. And even if it were all still there, they're only going to get, under the internal rules, a distribution of, let's take by way of example, 5%. Now, if they pay the whole, they have a right of contribution from their other partners who haven't paid, be it assumed, and if and to the extent that they succeed in recovering from their other partners, then the insurers will be subrogated to those further recoveries. But prima facie, the loss they suffer is a liability for 8 million, roughly, whatever it may be. And they get, initially, if the 7.5 million was still there, or the 6 million, or whatever it is, even if the whole lot was still there, they only get a 5% interest in it. That was the point that I understood was being made. It's sort of stripped to its simplest.
My lord, that I don't necessarily, in the context of the respondent's notice and the assumptions that one makes in order to get to the respondent's notice, that particular piece of analysis I respectfully wouldn't take issue with. What I was balking at, I think, what was, and it may be a misapprehension on my part, was a suggestion that one way or another, the distribution that, as I now understand it, what's emerged from these illustrative figures, that the distribution to salaried partners somehow falls out of account.
Let me ask Mr. Coleman whether that was part of the submission, because if it was, I'm afraid I hadn't understood it.
I can't say anything about any distribution to salaried partners. not in evidence. I'd have to take instructions in relation to that.
Well, I'm just asking you whether that was your point.
Well, no, my point is, for an insured, you look at whatever amount has been distributed to the insured.
Yeah.
And if money, some of it's been distributed elsewhere to distributed to salary partners, then one leaves it out of account. For an individual insured, you just focus on what that insured has received.
Leave it out of account in terms of the credit as against
Indeed.
the overall. So the overall figure is taken into account.
Yes.
But it's just what the individual personally receives that you set off against it on this counterfactual basis.
That's the point. Yes.
Yeah.
That may deal with it. It may be a misapprehension on my part. I thought, particularly in the context of the description with respect to the open offer, that it was being suggested that the open offer was in fact that only the words "or part of" in paragraph 4 of the open offer were now very significant, and it would only be 2 million rather than 4. But in any event, I think the exchange illustrates there's only a limit to which we can expect this court to get involved in figures that emerge as a result of illustrative percentages only. So if one is in the world of the respondent's notice, and if my learned friend submissions are accepted, then the form of relief I accept could not be expected to determine the position in respect of HMRC and the National Crime Agency at this stage. Each side has their own arguments in respect of it, but it's not something that I can sensibly invite this court to determine on the information that's before it. Can I then turn briefly to the scope of relief, which is the point that my Lord Justice Popplewell raised. And this may be a point for another day, but I should perhaps at least articulate, my Lord, what my submission is in respect of it, is that when one looks at the Brown-Rudnick statement of claim, the overwhelming thrust of that document, the statement of claim, is a claim arising from the misrepresentations made or said to have been made by Mr. Coulter, which resulted in the payment of the success fee. And it's a necessary constituent part of those claims that if the misrepresentations hadn't been made, the to and success fee wouldn't have been paid over. There is a residual claim in respect of breach of fiduciary duty made in respect of how the success fee was dealt with once received, one finds at the conclusion of the statement of claim. But as I read it, that is not a claim that would include a claim for the to and success fee, because it's dealing with the consequences of how it was addressed following receipt, not for the payment over of it. So the causes of action that result in a claim to loss and damage referable to the to and success fee are in my submission all consequent upon and have to rely on the contention that Mr. Coulter made a false or negligent misrepresentation.
Well, as you say, it may be a matter for another day.
It may be.
There are claims in contract negligence and so on, based merely on the fact of what was done or in terms of his involvement and so on.
As I say, it may be a point for another day, my Lord, but I thought I should identify my point. Well, unless I can help you any further, so my submissions have applied.
No, thank you very much. Mr. Coleman, I think if you wanted to, I'm not encouraging it, the way the point has been put on reply in relation to the jurisdictional point involved a slight gloss on the way it was dealt with earlier, in that there's an alternative application for permission if permission is needed. If you wanted to say any more about that, you can, but I'm not encouraging you to do so.
No, well, I mean, if you were to find that, and I'm saying this in my learned friend's favour, if you were to find that the only fault with the claim form was the absence of the words in substance, then I wouldn't oppose the application. But we say the problem goes deeper than that. Our position is that even that does not reflect the real issue before the court.
Thank you. Well, thank you very much, and obviously not just to you two, but to those behind you. We're very conscious how much work goes into what we see as front of house. We'll reserve our judgments. Can't give you any promises as to when you'll get them. They'll be handed down in the usual way. You'll get a draft. Everybody knows, I hope, of the embargo and how important the embargo is taken, and you may be in contempt if you breach it. Only typographical and administrative corrections, please, not an opportunity to re-argue the case. We'll invite you at the same time to put in your submissions in writing in relation to the form of order and any consequential matters, and the hand down will be, unless you hear otherwise, remote. Thank you very much.
Court rise, if able.